Welcome everyone, and thank you for attending the 16th annual session of the Cape Henry Collegiate Supreme Court. My name is Inez Baez.
I'm Cole Hughes, and we are your hosts for tonight.
6 student lawyers will be arguing the case of Grants Pass v. Johnson for the 9 justices today. The case raises the question of whether a city can make it a crime to sleep outside.
To be selected as one of our lawyers, these 6 students had to prepare and deliver a 5-minute argument to Mr. McGraw on behalf of the city of Grants Pass, and then prepare and deliver a 5-minute argument to Mr. McGraw in favor of Gloria Johnson and the homeless citizens of Grants Pass.
Since being chosen, they have gone through hours of practice in front of previous student lawyers, their peers, and practicing attorneys to prepare for tonight's argument. They will prepare, and they have spent a great amount of time and effort into this activity, and they will present their final argument tonight.
Now, Tamara Sergiani will give you a short presentation about the facts of the case and the legal arguments you will hear.
Okay, so Grants Pass is a city in Oregon with about 38 residents, and anywhere from 50 to 600 of those residents are considered homeless. And because there are not enough shelter beds in the city to house all of the homeless population, the lower courts have ruled that all of Grants Pass is homeless people are, by definition, involuntarily homeless. So in 2013, the city of Grants Pass began to enforce regulations that prohibited camping on public property. This included sleeping on streets, alleyways, sidewalks with any sort of bedding or sheets. A first-time violator would receive a $295 fine, and then after repeated violations, they would get a park ban for 30 days, and if they broke that park ban by going to a park, they could be criminally charged for trespassing. So Gloria Johnson and John Logan represent the class of voluntarily homeless Grants Pass residents, and they filed suit in the United States District Court for Oregon on the basis that the city's regulations would violate the amendment's protection against cruel and unusual punishment. The district court agreed, and the city of Grants Pass appealed to the United States Court of Appeals for the 9th Circuit, which also upheld the same decision in favor of the homeless. So now the court has appealed to the Supreme Court of the United States, and the court will be heard on April 22nd of this year. So real quick, the 8th Amendment, as it's written, is excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So the big question that the Supreme Court is going to be answering is, do the city's regulations violate the amendment's prohibition on cruel and unusual punishment? So some similar cases in the past, California convicted Robinson of breaking the law by being addicted to narcotics. The court sided with Robinson, stating that it was unconstitutional to punish a status, but it was constitutional to punish an act. And a similar case was Powell v. Texas in 1968. Powell broke Texas law by being publicly intoxicated, and and the court sided with Texas, stating that the law was punishing the act of being drunk in public, rather than the status of being a chronic alcoholic. And this one, the Judge White, who was part of the 5 judges that sided with the state, he stated that he would have sided with Powell had he provided more evidence that he couldn't go without drinking in public. So some of the petitioner's arguments include the 8th Amendment prohibits overly severe punishments after a crime, not whether a law itself is too severe. Fines and park bans are not cruel and unusual punishments. Unlike Robinson, but similar to Powell, the city of Grants Pass is prohibiting an act of sleeping on public property, not the status of being homeless. A person does not become involuntarily homeless just because there are not enough shelters to hold them. There are many other factors. All cities must be able to protect their citizens, including the homeless, and they can't do that without being able to enforce regulations such as these. Policy decisions like how to deal with homelessness are decisions properly left to representative bodies, not law courts. And then some of the respondents' arguments include in Robertson, the Supreme Court held that the law punishes someone for status as opposed to an act violates the 8th Amendment. Punishing the involuntarily homeless for sleeping does in effect punish them for their status, as sleeping is an unavoidable act. It's impossible for the homeless of Grants Pass to avoid violating the city's regulations as there are not enough shelter beds to house all of them. And while representative bodies like Grants Pass City Council have the primary responsibility for determining policy, the choices they make may not violate the Bill of Rights. And that's all. Thank you.
After learning more about the case, my co-host Inez Vias was inspired to write a poem about it. Carter will share it with you now.
This piece is titled A Silent Burden. In Grants Pass, where the rivers flow, a silent struggle of hearts lay low, while streets become a weary bed, and dreams are lost, unspoken, unsaid. Slowly, wary souls begin to plunge north, guided by the whispers of a distant north. In the embrace of night, they slowly roam, endlessly searching for a place to call their own. In Grants Pass, where the winter bites, hope flickers in the darkest nights. Amidst the chill of the cold concrete, a city's empty promise sends flickers through a dim street. In the darkness, hands reach out to ease the pain, quell the doubt. And amidst the homeless plight, a burden is shared, one where rouged hands bared. Each soul a story, a life to cherish, in the heart of a town that refuses to perish. Though challenges loom and trials persist, in Grants Pass, humanity lends a hand to coexist.
Thank you. Now it's time to get to the arguments. The lawyers will argue their side of the case in front of the 9 justices for 10 minutes each. The justices will interrupt the students with questions about the case, and the students are expected to answer on the spot with the time provided.
First, Katie Sardiani and Julius Pleva, please stand. They will argue on behalf of petitioner City of Grants Pass.
Second, Madeline Keogh and Logan Syke, please stand. They will argue on behalf of respondent Gloria Johnson, who is representing the homeless citizens of Grants Pass.
Third, Alana Tancredi, please stand. She will argue as amicus on behalf of the City of Los Angeles.
Fourth, Gerda Poliskaite, please stand. She will argue as amicus on behalf of the advocates of the unhoused.
After all the student lawyers have finished their arguments, the justices will then hold a short conference to vote on the cases. And then, over the next few weeks, they will write an opinion announcing and explaining their decision.
During this time, the students will not know who won. They must wait until the opinion is released. The 9 justices in this case are
Chief Justice Dr. Christopher Guerin currently serves as Cape Henry's 11th head of school and president. He is also the parent of Cape Henry student Christopher.
Sharon Goodwin practices law at Hunt & Andrews Kurth, LLP.
Manalita Holiday practices law at Joins and Guides. She is also the parent of Cape Henry graduate Josh.
Kevin Keller practices law at Wilcox and Savage PC. He is also the student of Cape Henry senior Olivia.
Wendy McGraw practices law at Hunton Andrews Kurth LLP. She is also the parent of Cape Henry graduate Matt.
Joshua Rees is a Cape Henry senior and was voted best lawyer in last year's program. He plans to attend the University of Tennessee next year.
Kim Shepard practices law at Troutman Pepper Hamilton Sanders LLP. She is also the parent of Cape Henry graduates Grant and Kate.
Skip Templeton is a vice president at RW Town Mortgage. He is also the parent of Cape Henry graduate Caden.
Will Trager is the head of the Cape Henry Upper School. He is also the parent of Cape Henry students Owen, Ella, and Lucy.
Now please rise as Ava Martin sings the national anthem.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of Cape Henry. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of Cape Henry, are admonished to draw near and give their attention, for the court is now sitting. God save Cape Henry and this honorable court.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets that glare, the bombs bursting in air, gave proof to the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Good evening, everyone. So just to remind everyone here, the students will be presenting, and attorneys have worked very hard to be ready for this evening. For my colleagues up here, just a reminder that we will allow the students at least a minute of presentation before asking any questions. Once a minute is up, feel free to ask questions. We will begin now with arguments. First, for the City of Grants Pass.
Mr. Chief Justice, may it please the court, my name is Katie Sardiani and I'm representing the petitioner in the City of Grants Pass, Oregon. The petitioner respectfully requests that this court overturn the decision of the U.S. Court of Appeals for the Ninth Circuit for the four following reasons. 1. The Eighth Amendment was only ever intended to regulate methods of punishment, not determine whether a law itself was cruel or unusual. Robinson was wrong in stating that, and this court should overturn that decision. 2. The punishment for breaking grants passes regulations is not cruel and unusual, as fines are often a very common form of punishment for violations of the law. 3. Even if Robinson is still a good law, grants pass regulations are not banning the status of being homeless, but rather the act of public camping, which applies to every residence. And 4, cities cannot be expected to protect their homeless citizens without first enforcing regulations such as these. To elaborate on the first point, the Founding Fathers never intended the Eighth Amendment to be used the way it was in Robinson. The Eighth Amendment was only ever intended to regulate methods of punishment, which means to prevent horrible inflictions imposed in vengeance of a crime, which comes from the U.S. Dictionary, not determine whether a law creating a crime was cruel or unusual. That is why they chose to use the term punishment, which means inflictions imposed in vengeance of a crime, If we look at the English Declaration of Rights, which is the model for the Eighth Amendment, the writers specifically included the phrase, "No more cruel, unusual punishment shall be inflicted for the purpose of deterring torture."
Counselor, I'm gonna interrupt you and just sort of jump to the punchline here. Where are the homeless supposed to go if they can't sleep outside in Grants Pass?
So there are actually a few options for them. It's not like there are no shelters within Grants Pass. There just isn't enough for the maximum capacity, which is anywhere between 50 to 600. But other places they can go include, there's a small house movement within that the UCAN is offering, a tiny house movement that is allowed to house them. What is this? Oh, there are some churches that are offering shelter, even though they does have involved strict religious requirements, but that's also just an option. They can also still sleep out on the streets just without any bedding. So those are also options, and any place with near Grants Pass that provides shelter but not within the city is also another available place.
Counselor, can you distinguish again for us, Counselor, can you distinguish again for us why this is not a status?
Yes, so Mountain City, California determined that a status is not allowed to be targeted, like the status of being a drug addict. Even if, I asked the court to overturn that decision, but even if you don't, if you look at Grants Pass's regulations, it's simply banning the act of public camping, which applies to every resident within Grants Pass, not just the homeless population. It's not in status because it applies to everyone. It is an act of public camping.
Counselor, I think you mentioned that they can sleep on the street without bedding. So is there a false dichotomy here going on where they can sleep without bedding, but not with bedding?
Yes.
So why is it so important that we enforce the rule, all the horribles that might happen if people are outside sleeping? Why can they sleep without bedding and not with bedding?
I believe it's because it becomes very difficult to start to distinguish, like what is a camping enclosure if it involves bedding, because that includes like public camping, and it's difficult to distinguish if someone is just like out and fell asleep on a bench or whether or not they're actually lying well. So I believe that is why the city of Grants Pass decided to specifically include the phrase bedding. So back to the argument I was making. So it was only under Robinson that, this back to the Eighth Amendment argument, that this, that they're bringing this under the Eighth Amendment when the Eighth Amendment only applies to punishment, it's not the law. So it was only under Robinson that the Supreme Court decided to extend Eighth Amendments to status crimes, and where they attempted to extend Robinson to argue that acts stemming from unavoidable conditions were also applicable, when that clearly goes against historical precedent. Every case before Robinson was only about the punishment. If the punishment was too severe, like the fine was too high, or it was disproportionate to the crime that was being committed, for example, like torture. Additionally,
Counselor, I'm curious. Do you believe that Grants Pass has an obligation, a legal responsibility to provide housing to those who do not have it within the city limits?
I'm just here to argue the legal argument of whether these camping ordinances violate the Eighth Amendment, and I do not believe they do, and neither does the city, because for the specific reasons that were mentioned, it's not status. This case is being brought under the Eighth Amendment when it's more so a 14th Amendment issue, and the 14th Amendment is all about laws being like targeting populations. So this would more so apply under that than the Eighth Amendment, because they're arguing the homeless population is being unfairly targeted by the law of public camping. But it's not the Eighth Amendment.
Can you explain a little more the distinction that you're making between the Eighth Amendment applying to the methods of punishment versus the crime itself?
Yes, the punishment here is fines, and the fines here are not excessive in any way. $295 isn't a large amount of money, the general population is which is what laws are made for. 295 is an outrageous amount for this case, and therefore the punishment is not excessive.
So if the penalty here was to throw them in jail for 3 years, you might have a different approach to it.
Yes, criminal charges can only apply after multiple repeated violations of this law. Looking at the bigger picture argument, it's important to know how this applies to cities past. Grants Pass. Though it is true the intention of Grants Pass's government was to move its homeless population out of the city, other bigger cities need to be able to enforce regulations similar to these in order to actually help their homeless populations. And just building more shelters is not enough because even the city as small as Grants Pass has anywhere between 50 to 600 homeless residents. That's a range so big that it becomes almost impossible to determine how many homeless residents are within the city. And if you start applying that to big cities like Los Angeles and San Francisco, that task becomes impossible. And if we keep expecting cities to start building more shelters for more more homeless residents who start flooding in, it becomes an endless cycle. And allowing regulations similar to Grants Pass for other places would be the first step in sort of getting people away from these camping enclosures where rapid drug use and disease outbreak are abundant.
If you criminalize the state of them sleeping in the park, and aren't you effectively barring them from living peacefully within the jurisdiction of Grants Pass?
Like I mentioned, it's not banning them from sleeping out, just sleeping without bedding. That's another side of the argument, even though it is arguably more dangerous. But if you start putting fines in place, that for like other cities besides Grants Pass, it needs to be like a baseline punishment for people to start taking the laws seriously and start moving into shelters that can like actually help them and rehabilitate them. The governor of California actually filed an amicus brief for this, in which he argued that he wants to be able to enforce regulations similar to Grants Passes, because they do have facilities equipped to handle the homeless populations. They just can't get people off the streets.
Yeah, Councilor, didn't Governor Newsom though say that they believe the shelter should be provided to homeless first?
I'm sorry, can you repeat that?
The shelter should be provided to the homeless first. You do not challenge that, correct?
He never stated anything about it initially, as far as I'm aware when reading the brief.
Counselor, let's state for a moment that well, with your line of reasoning about not punishing sleeping, just sleeping with bedding, I'm a bit concerned about the implications of allowing such a law. Let's say this goes forward, and now all of a sudden I have a beautiful young family in the park on a fall day, and they're having a picnic, and the toddler falls asleep with a blanket. Law enforcement, I suspect, would want to equally enforce this law and not just target a certain demographic that we deem to be unsightly or people who are trying to get out of our city. And so now all of a sudden we have a young family who's being fined because their child fell asleep with a blanket. How can you ensure that the law is not targeting unfairly, which could perhaps be defined as cruel and unusual punishment, the homeless population, and how can you ensure that it's going to be equally enforced amongst all demographics within the city?
With the example you just mentioned the picnic and the toddler falling asleep with a blanket. That then applies to them too, the law, and therefore it's not targeting the homeless population, because I guess the family is as equally equally charged with the crime.
All right, thank you. Your time is up. This point, yeah, we'll hear from Dr. Holmes.
Mr. Chief Justice, may it please the court, my name is Madeline Keogh, and I represent the respondents Gloria Johnson et al. The respondents respectfully request this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit. The court should affirm the decision for the following reasons. 1, the ordinances are punishing involuntary conduct that results from being homeless. 2, the punishment for violating said ordinances violates the Cruel and Unusual Punishments Clause, just as in Robinson v. California. And 3, the laws serve no true purpose other than to deter homeless people from living in Grants Pass. The city has tried to claim that this is a case about public camping. However, the city ordinances outlaw sleeping in public, not just public camping. One law states that no person may sleep on public sidewalks, streets, or alleyways at any time, while another does prohibit public camping specifically, and it's defining camping as using bedding in any public location, whether or not that includes the use of a structure, permanent or temporary. Under these ordinances, you could possibly be breaking 2 laws if you were to sleep in the street with a blanket. And because of these laws, it is impossible for a homeless person in Grants Pass to exist without breaking the law. Sleeping is an involuntary act that is a result of being alive, just as breathing is. Therefore, for a homeless person, sleeping in public is an involuntary consequence of being homeless. The homeless population in Grants Pass can be anywhere from 50 to 600, and all parties agree that there are not enough beds to support the population. And since there are not enough beds, homelessness becomes an involuntary status rather than a voluntary conduct.
Counselor, I'm going to stop you right there, and much like with your colleague, I'm going to sort of cut to the chase as to what I see as the problem in this argument. That the argument that homelessness itself is involuntary solely based on the number of beds is something that I'm struggling with. How do we know any number of these people don't have relatives that will take them in and that they aren't truly involuntarily homeless?
The city has yet to prove that anyone in Grants Pass, or especially in this class action suit, is voluntarily homeless, rather. And even if someone were to say that they don't want to go to a shelter or stay with a relative, as you mentioned, there's often involuntary circumstances that prevent them from going to those shelters or other locations, such as addiction, mental health disorders, or other similar involuntary circumstances. And again, since there are none of beds, homelessness is becoming an involuntary status, so their action of sleeping in the streets is not voluntary conduct. And the cold temperatures and rainy weather in Grants Pass make some type of covering absolutely imperative for survival.
So I do have a question to your initial point. You stated that there's no real purpose to the law other than to deter the homeless.
Yes, sir.
And you see no other purpose for this law?
Well, the city has made previous efforts to eradicate their homeless population, which is evident by the city buying bus tickets for all the homeless people out of the city, and they were then returned because the other city did not want them there. And there's no true evidence that this law will actually benefit the homeless population, because if this law or the ruling of the U.S. Court of Appeals were to be affirmed, that would actually lead to a much more productive scenario, because the cities would be required to, they could not enforce this law if they do not have enough shelter beds, so they would have to make up shelters.
I'm asking about the purpose of the law. You said there's no other purpose other than to deter or eradicate the homeless.
Yes.
Is there any balancing here? Does the public have a right? Do the citizens have a right to a park without homeless, or people have mentally ill or drug addictions or other issues?
So while the public and the city have the right to enforce their public safety, which is a very big issue when it comes to the homeless population, the city just does not have the right to violate the constitutional rights that all citizens of America have. And because this is an Eighth Amendment case, which the Eighth Amendment outlaws cruel and unusual punishment, this is why this law is violating a homeless person's fundamental constitutional rights. And in the case of Robinson v. California, the ruling was that a law criminalizing a status of being a drug addict was unconstitutional. So that ruling basically said that a law punishing a status, such as the California law, violates the Eighth Amendment because the status is involuntary. And while this Grants Pass law does not explicitly punish a status, the act of sleeping in public is an involuntary consequence of the status of being homeless.
Counselor, let's agree for sake of this argument, that they're involuntarily homeless and that's their status. But it's only a civil fine if they're issued a citation. It's a civil fine. It doesn't become a criminal offense until that person takes the affirmative act of then sleeping in a city park that they've been banned from. So we have several steps and layers to this law. So agreeing that the status is being involuntarily homeless, if they choose to go into the public park after being banned versus sleeping in an alley, sleeping on a sidewalk, which is not criminal, it's just the act of moving into the public park that makes it criminal. Isn't that a choice and now an act by the person?
So when the person is given the first civil citation, they then cannot break the law again at risk of criminal trespass, as you mentioned. However, the truth of the matter is that they simply don't have another place to go. They cannot, even if they were to sleep in the streets, well, sleeping in the streets and on sidewalks is illegal by the other city ordinances. They couldn't sleep in a park with a blanket, and sleeping in Grants Pass, especially in the winter, without any sort of covering, leads to, it increases the risk of hypothermia. And a 2010 survey actually found that 700 homeless people die of hypothermia each year in the U.S. So since they don't have the option to protect themselves or go somewhere else, this is proving that the law is punishing their status. And if this law, or if this case were to be overturned, there's nothing stopping other cities or towns from enforcing a similar law, and therefore if they were to just get up and move to another place, then they could be enforcing the same laws in the new place, and therefore they're just going to have to move again. So these homeless people would just have to go on a trek all across the country trying to move, and a lot of them just don't have the means to really do that. And in the case of the criminal trespass and the repeated citations, the fines rack up to be an excessive amount, and a criminal trespass has an additional $1,250 fine and up to 30 days in jail. And that is a very extreme punishment in relation to the nature of the crime. The Robinson case also rules that if a status or if a law prohibits something or provides a punishment for something that is very extreme in relation to the magnitude of the crime, it is also cruel and unusual punishment.
Counselor, quite simply, how do you define cruel and unusual punishment?
Cruel and unusual punishment is anything that is excessive, anything that is dangerous, or anything that is extremely out of line compared to the magnitude of the crime. So in this case, the excessive fines rack up to be, it could end up being thousands of dollars for a homeless person who doesn't really have any sort of income in many
Counselor, if someone is actually incarcerated, are they not getting a warm bed and meals? Is that cruel and unusual punishment?
Well, a jail sentence does provide a place to stay. This further impacts a homeless person's ability to get a job or any sort of shelter in the future when they are released from jail. So it's really just pushing the homeless people back even further than they already are. And that's a serious issue because, again, the city's trying to claim that this law helps the homeless people, but in reality, it's just pushing them further back and restricting their rights that they are owed under the Constitution.
Counselor, quickly, let's say we affirm your decision from the Ninth Circuit. How do you propose that camping in public spaces, how would you propose a solution to the infringement that this might make on disabled persons' ability to walk through sidewalks, or maybe children stepping over paraphernalia like needles and other things in public spaces, on their way to school or on their way to work?
So while the enforcement of this law, or a similar law, would be a bit interesting and up to law enforcement, the case that's being argued here, may I briefly conclude, is just the fact that this law itself is unconstitutional. It's just the ruling that this law cannot be allowed. Other laws for public camping are not necessarily unconstitutional under this ruling. Thank you.
Thank you. counsel for the city of Grants Pass.
Good evening. Mr. Chief Justice, may it please the court, my name is Julius Pleva, and I am representing the petitioner, City of Grants Pass, Oregon. Petitioner respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Ninth Circuit. This court should overturn the Ninth Circuit's decision because the Eighth Amendment does not place restrictions on what can be a crime. The punishment for the violation of the law is constitutional, and because the law does not punish people for a status, but rather for an act of conduct. Additionally, cities need to have the ability to make laws in public places to maintain order in their community. Grants Pass has passed a general ordinance law that bans camping in public places or establishing a stove with the intent of maintaining a temporary place to live. First, the Oxford Dictionary defines punishment as, quote, the infliction or imposition of a penalty as retribution for an offense. It is in the definition of the word that punishment is in reaction to the violation of a law and does not pertain to the law itself. The Eighth Amendment's purpose is to prevent the cruel or unusual punishment for a crime. It does not dictate what can or cannot be considered a crime, as this is the job of the 14th Amendment's Due Process Clause. The security of the Eighth Amendment is to ensure that all persons convicted of a crime do not receive any barbarous methods of punishment. Additionally, by this standard, neither the $295 fine for violating the public camping ordinance, nor the prosecution of repeated offenders for criminal trespass, which includes up to 30 days in jail, are cruel or unusual in any sense, as the main method of punishment for centuries has been fines and imprisonment. As stated in the case Buglug v. Cressive, punishments that are considered to be unusual are those which have fallen out of use. Fines and prison sentences are far from falling out of use, nor are they cruel, as they do not, quote, superadd terror, pain, or disgrace.
Counselor, does it bother you? You're speaking to the result of the conviction for the crime. Is there any part of your analysis that would say that any conviction can be cruel and unusual punishment if a population is unfairly targeted with that crime?
Yes, that is correct. No one specific population is allowed to be targeted by any specific law. However, this being a general ordinance law means it will be enforced to everybody and not just a person of a specific group or status.
Would you agree that it is specifically intending, even though it's addressing acts and actions, I think is what it's saying, that it's specifically, transparently intending to target the homeless?
I do not believe that this law is intended to maliciously attack the homeless people. It is rather a way to keep just any people sleeping in general off of the city's public property, as there have been complaints from the residents that the tents are in the way of like public playgrounds and stuff like that. So this law is really just to prevent this, as there are other places for these people to stay. Grants Pass has a lot of campsites which charge a small fee or annually to be able to stay overnight in a tent, as one would do at a campsite, as well as churches, which also, assuming you attend Mass, but this is not the only way. Additionally, there are friends or relatives who may house these people, so the streets are not their only option. They have multiple other options, which might seem more difficult for them, which is why they are choosing to stay in these public parks. Additionally, Robinson versus California states that one cannot be punished for a status, such as an addict, alcoholic, or homeless person. But as upheld in the case Powell v. Texas, punishment on account of the direct conduct of the individual is permitted, even if such person is affected by an involuntary status for which said conduct originated.
Counselor, in that case, the deciding vote actually focused in on the involuntary status and said that if they had more evidence that the person was involuntarily intoxicated in public, he may vote differently. What if on an individual basis, a homeless person was able to demonstrate that they were in fact involuntarily homeless?
Well, the city of Grants Pass does not have regulations such as that. However, these people do have additional places to go, such as these campsites that I previously mentioned. This well as churches or family members' houses. And there are alternatives that are provided because homeless shelters are still there. There's just not enough for every single person. So there are alternatives to this and ways to avoid this law and not be punished as such. The city's law is not a prohibition on the status of homelessness, but rather a generally applicable law that prohibits the act of camping in public areas. If this law preventing public camping is declared unconstitutional on the basis of involuntary status versus a direct act of conduct, the court must recognize that affirming Johnson opens the door to declaring laws banning public intoxication, drug use, or nudity and sex laws unconstitutional under the same principle. In order to have a well-functioning society, cities need the ability to make laws that establish order. If Johnson wins this case, it will hinder the protection of all citizens who reside there should there ever be a public health hazard or natural disaster that would require the cities to legally intervene. This also bans the city's ability to make laws directed at a specific status of people in times of need or crisis. For example, if aid were to be presented and new shelters were to be built, yet people refused to go into these shelters, the city would need a law that would be able to allow them to force into the shelters because there is now aid available. As some people who are struggling with mental health or substance abuse issues will sometimes be reluctant to seek help because it is either difficult or they are just mentally not able to. So just sometimes a nudge from the law, as these very light fines would suspect, is that they would allow them to go into the shelters without forcing them outside of an active law.
If the city actually did have enough shelters, though, that would take away the involuntary status, correct? And then the laws could be enforced.
That is correct. But these laws can still be enforced even if there is not shelters exceeding the amount of homeless people, because it is very difficult to keep track of the homeless individuals as they do not have a specific place of residence. So to be able to count them in places like LA or Seattle or Portland, where there are more than 75,000 people who do not have a home, and sometimes they move between city and city. So to conduct a daily count of shelter beds versus people who are involuntary homeless is not a good use of the city's resources, nor does it help to solve the problem. So the other side will try to say that this law would be okay if there were enough beds for every homeless person, but that is just not the case because it is very difficult to prove how many homeless people there are at any given moment versus the amount of shelter beds that there are in the city.
So you want us to look beyond this Grant Pass law and what's going on in Grant Pass and be cognizant of what this might do in other cities?
That is correct, because this Supreme Court decision will not only overturn Grant's Pass law right now, it will also overturn every future law that might want to be implemented regarding this same issue. So, for example, if there were more aid presented, this law would still be unconstitutional to force homeless people off the streets to try and get them into shelters, which would make some cities who are trying to actively solve this crisis, it would be a lot more challenging for them to solve it by getting these people into more economic reforms, such as shelters or job programs, if they are unwilling to move off of the streets, and the cities do not have the jurisdiction to make a law against them. The homeless crisis is a major problem throughout America, but extending the Eighth Amendment beyond its limits and disallowing this to be dealt with on a state or city level will only hinder a solution. The enforcement of generally applicable laws to prevent camping on public property is neither a cruel nor unusual way to try and aid in the solution of this pressing social problem. For the foregoing reasons, petitioner respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Ninth Circuit. Thank you.
Thank you. We'll now hear the second argument for the homeless.
Mr. Chief Justice, may it please the court. My name is Logan Syke, and I represent the respondent, Gloria Johnson, et al. Respondents respectfully request this court to affirm the decision of the United States Courts of Appeals for the Ninth Circuit. The court should affirm the lower court for the following reasons. First, Grants Pass enforced unconstitutional camping ordinances against the homeless, which prevent the homeless population from sleeping in city parks, even though there are insufficient shelters and housing. It is cruel and unusual to punish the homeless for simply existing. Second, punishing someone for an involuntary status rather than conduct is unconstitutional. Finally, Grants Pass's ordinances against the homeless residents would have been detestable to the founding fathers' interpretation of the Eighth Amendment. Grants Pass, Oregon has an approximate population of 38,000, with 50 to 600 homeless residents. All parties agree that there are insufficient shelter beds to house the city's homeless. To combat this, the city revised its anti-camping ordinances to allow homeless residents to sleep in city parks. However, the city's argument regarding the revised anti-camping ordinances is an illusion. The amended ordinance prohibits homeless residents from using bedding, sleeping bags, stoves, lighting fires, or building structures. Also, each count of criminal trespass on public property triggered the 30 days of jail and the $1,250 fine, with infinite violations possible if the person remains in Grants Pass. A violator is thereby continuously guilty of trespass whenever they are not serving jail time for their last violation. This is a clear violation of the Eighth Amendment. In Inger v. Wright, the court held the Eighth Amendment imposes substantive limits on what can be made criminal and punished as such. Substantive limits are restraints limiting what the government shall and how.
Counselor, would you be okay with a lesser punishment at each level? Is it the actual ordinance prohibition that you're saying is cruel and unusual? Or is it the punishment of it, the enforcement of it?
Yes, it's both. It's that you're punishing someone for an involuntary status and the homeless residents for their involuntary status as homeless because there's not enough shelters, which is unconstitutional, and that the fines are too much for homeless people who are forced to sleep on the streets, not the money to pay fines, especially when they are being returned from civil citations and through criminally trespassing laws up to $1,000 fines.
What if, I guess my question might be more clear, what if each violation was $10?
That is less unusual. That's more regulatory rather than $290 fine, which are absurd considering that you're punishing homeless people.
So if the fines were less, the punishment were less, would you be okay with
Not with
this?
the fact that they're being punished for their status. If there were enough shelter beds and the fines were $10, then the fines would be completely fine. The fact that there are not enough shelter beds makes that involuntary, which even if they were $10 fines, would still be unconstitutional.
Do you have a position on how many shelter beds would be necessary?
Enough to fit the amount of homeless people based on the 50 to 600 beds.
I guess my question is, if there's 500 homeless, do you need 500 beds, according to your argument, or do you just need enough beds to house the number of people that may need shelter for that night? Maybe, I don't know what the number would be, I don't know if you proposed any number.
If each homeless person had a bed, they would not be forced to be sleeping on the streets, and therefore,
would 100 beds be enough?
no, if there's 50 to 600 homeless, you go on the back test. The Ninth Circuit relied on its earlier decision in Inger v. Wright by rendering it unlawful to sleep anywhere on public property with so much as a blanket to survive the cold. The ordinance-
So is it your position that the city can't regulate these homeless campsites at all?
No, the cities have regulatory ordinances put in by the Constitution, but the fact is that they are punishing them for that. Cities like Los Angeles and San Francisco need the power to regulate the homeless, but they cannot punish them for their status. Punishing them is what makes it unconstitutional.
How else can they enforce any sort of regulation if there's not some punishment or fine associated?
They can enforce it by helping them. The main problem is that drug epidemics and having homeless in their parks. The fact is that they give them homeless and they give them houses and help, they can get them off the streets by regulating without having to fine them.
So if it's voluntary, right? So if a homeless person is offered that bed, declines it, then the law's fine.
Yes.
You would simply on the your assumption that they're involuntary.
Yes.
And you believe all the homeless in Grants Pass are involuntary.
The city's provided no evidence that there are not involuntary homeless. The ordinance has effectively punished the city's involuntary homeless residents for their existence in Grants Pass. This ordinance is an extravagant attempt to force the homeless out of Grants Pass. The transgression of cruel and unusual punishments is substantive limits. As established previously, homeless in Grants Pass are involuntarily homeless due to insufficient housing, therefore making their condition a status, not a conduct, which you cannot punish. Robinson v. California and Powell v. Texas are previous Supreme Court decisions that state a person may not be prosecuted for involuntary status or the product of status, but may be prosecuted for a conduct. In Robinson, the Supreme Court struck down, under the Eighth Amendment, a California law that made it a criminal offense
is still okay to punish someone who has illegally obtained narcotics or drugs under the law. Therefore, this makes the status first comment argument. Also, in Powell, the court divided 414 over whether Texas violated the 8th Amendment under Robinson by prosecuting alcoholic for public drunkenness. In a plurality opinion, Justice Marshall upheld the conviction of Louis Powell on the grounds that he was not punished based on status alcoholic, rather than the act of stress of being drunk in public. But Powell failed to prove his status as alcoholic compelled him to violate the law by appearing in public, which led to his conviction.
Excuse me, Counselor. You're here on the argument that it's unconstitutional because they're involuntarily homeless.
Yes.
But the implications of accepting your argument are that there's no enforceability. It will then no longer allow the town to regulate, in the sense, a bunch of people come out of a bar stumbling drunk and they just want to sleep in the park. We no longer have an ordinance or an enforcement mechanism. Or if a bunch of college students just want to camp out without getting a campsite fee, they'll lose those regulations. What are your comments?
That is different because that is conduct. The homeless people here are proven to be voluntary because there are not enough shelters. The fact that those college students say jumping out of a bar would be conduct. They can choose to sleep in that park, which the ordinances are still fine if it is conduct. But here the homeless are being punished for their violation of their status. As the Circuit recognized, Robinson and Powell stand most obviously for the proposition that the 8th Amendment prohibits punishing people for having a voluntary status. Being involuntary homeless is such a status, and when shelter is unavailable, means you have nowhere to exist but outside. Sleeping outside beneath a blanket because they cannot find shelter is thus inseparable from the respondent's status as homeless individuals, and beyond what the state may constitutionally punish. This decision, along with other past court decisions, make the status of the homeless of Grants Pass involuntary, and liable to be punished, as is cruel and unusual to punish them for their status.
Counselor, I'm sorry to interrupt. You briefly a moment ago said that the involuntary status of being homeless was due to the lack of beds. The implication of that is that the full responsibility of housing then is on the city, which in a way then makes it so that housing becomes a universal right enforced by law. The trickle-on effect that I fear might happen is then what's to stop the homeless population from saying we are poor due to lack of jobs, and the city being then also responsible for providing universal employment. Where does that end? Why is this argument okay, given the fact that it may have far-reaching implications down the road?
This is different because the homeless are not being punished for being poor here. They're never being punished for being poor. Homeless are being punished because they're sleeping on city parks. They cannot come and say that they're poor and be punished for it. There's no law punishing the homeless for being poor. It's similar to Robinson, where in Robinson, he was punished for the law was saying that there was someone is.
So are there other involuntary status categories that people could, I mean, you talked about addiction before, and you're talking about homelessness.
Yes.
Are there others?
Yes, if you can prove that it's involuntary.
So if I proved I was food deprived and hungry, if I was hungry, you have to have food, right? Much like you have to have shelter.
Yes.
So where does that go?
The fact that you have to prove that you were able, you have no way to get food. If you're homeless with no money. But hunger is a little bit different. It's not punished for it. It might be a status, you're not being punished for being.
What if they steal food?
If they steal food, in fact, that's stealing. That's a kind of choosing to steal. You're choosing to steal something.
They're choosing to camp where they're not allowed to.
The fact that these are, it's similar but it's different. The fact that it's very much harder to prove that you are being forced to hunger because you can find many things to eat and also drink, which is a little bit different than homelessness, which are proved by the amount of shelters, which they are proved to. It's much harder to prove that someone is being starving because there's not taking into account soup kitchens, people that will feed them. There's a much more comparison of.
Are they being punished for the act of camping or the act of sleeping?
Both in a sense, because camping applies. Although the city attempts to normalize this punishment scheme as a modern-day version of poor and vagrancy laws, the city's enforcement of these efforts have been a cruel departure from societal norms during the founding era. Poor laws are historically used to punish those of able-bodied who would not work. In other words, someone who is voluntarily breaking the law. The city's ordinance do not adhere to this, but rather punish people for living without shelter access, regardless of whether they have any choice in that. Under the city's enforcement regime, it makes no difference whether someone is sick, disabled, elderly, city's ordinance is radically different from the vacancy laws of early America. An example
We wrap it up.
is,
I'll give you a few seconds to do this.
yes. An example is the Founders Era Pennsylvania law that prescribes compulsory labor for all persons who refuse to work for the usual common wages of other laborers. They provide maintenance for poor, old, blind, impotent, and lame persons, other persons unable to work within the city. It was only the voluntary refusal of work that provided the grounds for punishment under vacancy laws. For the foregoing reasons, respondents respectfully request this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit.
Thank you. We are now going to hear an amicus from the City of Los Angeles, just to let the audience know and to remind my colleagues that there will be no questions.
Mr. Chief Justice, may it please the court, my name is Elena Tenretti, and I'm representing the City of Los Angeles, California. The City of Los Angeles respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Ninth Circuit for two main reasons. First, cities are actively working to improve their dealings with the homelessness crisis, and second, the encampments are not safe for the people living in and around them. Grants Pass, Oregon is not the only city in the United States to face a homeless problem. Almost every other city across the nation faces the same difficulties, and some to an even greater degree. Specifically, the state of California and the city of Los Angeles have been dealing with homeless encampments. In recent years, they have been working on legislation and with nonprofits to discover new ways to combat the crisis they are facing, to help those who are suffering from it. California has created numerous programs and even built housing for the homeless across the state already, and is still working towards building it out more. So far, the state has invested money into homeless programs and nonprofits and implemented the CARE Court program that will bring some of the most difficult to serve populations into the system through court-adopted plans to provide them with available social services and housing. California has also specifically invested money, $700 million of it, in fact, towards creating new ways to support the homeless and to also connect them with places they can live instead of on the streets. As a city, we have also been working on solutions to help the homeless. We currently operate 22 safe parking programs that provide vehicle dwellers a safe and legal place to park and sleep at night. By upholding the ruling handed down by the Ninth Circuit, this court would be undermining the efforts the state has already put towards helping the homeless, as the first step to getting the homeless into housing is getting them off the streets. Homelessness is indeed a crisis, but each state must have the autonomy to solve it on its own and at its own pace. What works for Delaware might not be what works for Illinois. If the court decides to prevent a state from being able to enforce the legislation that they're making in regards to homelessness, then state and city governments will never truly be able to help the homeless population. As I previously mentioned, states and cities are trying to help the homeless get off the streets, and if the city has no way to motivate them into using these programs that they are already investing millions of taxpayer dollars into, then they are proving useless, and the homeless population will continue to be homeless and unable to support themselves. These fines and small amounts of jail time are just one way to encourage the use of the work already happening. If the court upholds the decision in Grants Pass, then we will have no way to motivate the use of these programs, and they will become ineffective and wasted. If cities were forced to provide enough housing for all their homeless, as established in Grants Pass, then there would be no way for the city or state to enforce the moving of homeless people into the provided housing. Many homeless people choose not to work towards improving their living situations, such as getting a job, because of addiction or mental illness. In fact, they believe that they cannot support themselves or even deserve to be helped. If given a choice, they would rather stay where they are. The National Alliance to End Homelessness stated that even with the addition of more shelter beds nationwide, fewer people are staying in these facilities, a fact supported by the U.S. Department of Housing and Urban Development. In Grants Pass itself, Shelter utilization has fallen 40% since the court banned the city from enforcing homeless legislation. If the city has the ability to use more influential tactics, such as the risk of a fine, to motivate the homeless and to move supported people into housing programs, it is more likely that those affected by homelessness would be more aware of the benefits and help provided for them. Cities are trying to help, but one obstacle preventing them from helping at capacity is the fact that they are facing litigation because of the decision made in Grants Pass. The federal court can decide the law, but the specifics are hard to determine, especially when it is not up to the state to decide. Time, money, effort are all valuable resources within a city, and they are being spent on these litigations in court rather than for the homeless people that they are about. Currently, the city of Grants Pass itself is facing litigation both for enforcing public space property storage regulations and for failing to sufficiently enforce them. Furthermore, the homeless encampments that exist are currently detrimental to the health and safety of both those living in them and around them. These encampments are breeding grounds for illness and disease such as tuberculosis and typhus. There is a lack of access to restrooms and places to dispose of garbage, so the homeless people are living in their own excrement and among things like dirty syringes. In our own city of Los Angeles, the homeless population is 4.5 times more likely to die from coronary heart disease, according to the LA County Department of Public Health. It is not only the physical health of these homeless people, but their mental health as well. Many homeless people are homeless because of a chronic mental illness or an addiction that causes them to be unable to hold a job or find any stable source of income. Again, according to the LA County Department of Public Health, the homeless population within the city is 8 times more likely to commit suicide than the general public. By allowing cities to enforce these laws, we will be able to guide those affected towards a better outlook on life and on the road to mental recovery in a facility that is specifically equipped to help them. Crime is also a large factor in the safety of those living in and around these encampments. The homeless population is more likely to participate in and be a victim of violent crimes. And a prime example of this is that the homeless are 15 times more likely to be murdered than the general public. Not only that, but their deaths are frequently the result of violent and traumatic injuries, such as stabbing and gunshot wounds, according to the Bay Area Council Economic Institute. By allowing cities to enforce these laws, we will be able to decrease violence and increase the sense of safety for all parties involved, something that is a central pillar to us all cities' purposes. This effect is not only felt by the homeless. The people living around the homeless are also seeing the increase in violent crimes in their area. In the city of San Francisco, a city which shares a similar percentage of homeless residents, homeowners were counted being threatened with firearms at their front door and having their properties broken into and vandalized, which has even driven some residents from their homes. Those living adjacent to the homeless are not only feeling the effects in terms of crimes. In Phoenix, where there are no homeless regulations, homeless residents regularly defecate and urinate in the streets, gutters, and on private property, set fires, loiter on or near privately owned businesses and residents, and partake in the use of drugs and alcohol, according to the city of Phoenix itself. Do we truly think that by having no rules surrounding homelessness, we will be helping those affected? By having no legislation and no way to enforce them, we will only enable the homeless to continue being homeless. Legislation such as that introduced by Grants Pass is only one of many ways to help get the homeless out of their current situation and on the road to recovery. If we want to help each and every citizen of our country, rules must be made and followed. For the foregoing reasons, the City of Los Angeles respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Ninth Circuit. Thank you.
We will now hear the second amicus from the Advocates for the Unhoused.
Mr. Chief Justice, may it please the court, my name is Yurda Polovskaita, and I am representing Advocates for the In-House, an amicus for the respondent Gloria Johnson et al. And we are respectfully requesting this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit. This court should uphold the decision of the Ninth Circuit for the following reasons. 1. Laws such as grants passes the health and well-being of the homeless community at risk. 2. They perpetuate a cycle of homelessness instead of alleviating the issue. And 3. They serve no real criminological purpose, existing instead as a means to try and get rid of the unhoused population. First, upholding the unconstitutional grants pass law would allow for more such inhumane rules against the population which the government should be protecting, and the homeless population in America would be significantly endangered. In colder cities with less availability for shelter beds, which include major cities like Chicago and New York, the criminalization of sleeping outside under a blanket would increase risks of hypothermia and other such illnesses, in addition to forcing sleep deprivation upon an exceedingly large population of around 600,000 Americans. Unhoused individuals are already at a higher risk of dying of hypothermia than the average person. A 9-year study of emergency room patient records in Toronto shows 25% of all hypothermic injuries and 20% of all hypothermic deaths occur among homeless individuals, which are disproportionately large numbers. This risk is created by the fact that homeless people spend the majority of their time outdoors. When temperatures begin dropping in the winter months, surviving the night becomes a daily concern, made only worse by prohibition of blankets for protection. Such forced exposures are forms of torture. The implementation of laws such as grants passes makes individuals who are already vulnerable due to their involuntary state of living choose between torture and banishment. Although not ordained by law, this banishment would occur due to a law which provides leaving the city as the only alternative to freezing, which is indirect ordination of banishment. Neither of these options is viable and should not be forced, as the homeless population has no way to avoid sleeping outside, no matter the weather conditions, and should not be forced to leave their hometown, family, and community for the sake of survival. Punishing an individual in any way for not making that choice is cruel and unusual and a direct violation of the 8th Amendment. To side with petitioner will not only harm the homeless population, but it will also negatively affect cities' communities at large. It's important to consider what will happen at the enforcement level of the laws petitioner seeks to protect. The involvement of police forces to enforce these laws will increase the potential for violent encounters with civilians and divert police resources from solving actual crimes. Police encounters in non-emergency situations are already at higher risk to end in violence, but when it's an interaction with unhoused people, the risk runs even higher. Black people are 4 times more likely than white people to experience homelessness, with similar statistics applying to people of color at large. 20 to 25% of all homeless people suffer from mental illness. Both of these demographics are already at a higher risk of encountering police violence. Black men are 2.5 times more likely to be killed in a police encounter than white men are, and individuals with mental illness run at 16 times that risk. Considering these statistics, the homeless population will be at risk of violent police encounters where laws criminalizing homelessness be allowed and passed, as the typical homeless demographic already experiences that risk. Police officers are not social workers. They are not equipped to address the struggles of the unhoused, like mental illness and addiction, when forced into interaction through enforcement of such laws. Homelessness is not a crime, it is a social issue, and to expect police officers to handle the homeless as criminals is to take away police resources from solving high-level crimes within communities. The court needs to take these implications into consideration when deciding on the ruling of this case. Second, one needs to consider the misleading purposes of banning public property campaigns. No person would choose to be homeless. This is where petitioner and amici have a wrongful solution to a large-scale problem in the United States. Criminalizing a lack of shelter will not force a person to find housing. If that was an option, the person would not be unhoused in the first place. Placing fines and charging jail time on people who already lack the proper resources to find real shelter only perpetuates the cycle of homelessness. A national 2018 study by the Prison Policy Initiative found that formerly incarcerated people are 10 times more likely to experience homelessness than the average person, and that up to 15% of all inmates experience homelessness in the years preceding and following incarceration. These statistics make sense. The transition from prison to community is hard. An ex-convict has to face the challenge of that status when looking for job opportunities post-incarceration, in addition to the economic struggles which arise from having lost time in prison. And if the ex-convict did not have the stable support of a place to call home prior to incarceration, these challenges become even harder to overcome, making it nearly impossible to break free of the cycle of poverty. As an alternative to drafting more cruel anti-homeless laws and hoping it will make homeless people stop being homeless, the city should instead focus on providing more affordable housing, which is the real root of the issue across the nation. Large-scale surveys show that 90% of all unhoused people are unable to find permanent shelter due to exceedingly high costs of living. The lack of affordable housing is a nationwide crisis, and is most prevalent in cities with large homeless populations, which is no coincidence. For example, Los Angeles is a leading city in regards to homelessness, with approximately 1/3 of all homeless people in America being LA residents. Unsurprisingly, at least half of the city's renters spend 30% of their income or more on housing, which is the definition of rent burden and the prime sign of house unaffordability. This pattern is consistent in other places with housing affordability crises like in Oregon, New York, and Miami. For being a leading city in terms of its homeless population, however, Los Angeles has put in significant efforts in alleviating the issue without the use of harmful criminalizing laws. Instead, the city has built more temporary shelter homes. These types of places help individuals ground themselves and are a first step in allowing them to rebuild their lives. Seeing these individuals as being part of the community instead of alienating them is the only way to begin addressing the issue. Third, criminalizing homelessness itself has no legitimate penological purpose. The four penological principles are retribution, deterrence, incapacitation, and rehabilitation. Since no individual is harmed by another person's choice of sleeping place, retribution here is not applicable. As discussed earlier, deterrence is not possible when sleeping in public due to homelessness is unavoidable. Similarly, incapacitation is only possible if the individuals are provided with shelter and therefore have the choice to sleep someplace other than public property. And since fines do not help a person afford housing, rehabilitation is not the goal of this punishment either. As the Grants Pass law does not meet any of these principles, it's proved that the city's goal is the erasure of its homeless population, and was not passed with consideration of the population's well-being. Governments should seek to eradicate homelessness, not homeless people, and this court has the opportunity to steer these governments towards such policy decisions by upholding its role of protecting individual rights against unlawful decisions of elected officials, as was the intent of its creation. For the foregoing reasons, Respondent amicus advocates for the in-house respectfully request this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit. Thank you.
On behalf of my colleagues, I'd like to ask the room to join us in recognizing these student lawyers for doing a tremendous job tonight. I'd also like to thank Mr. Scott McGraw, who organizes this event year after year. Thank you, Scott. And with that, the court is now in recess.
All rise.
Congratulations to all of our lawyers tonight. You all did an amazing job, and the justices have a tough decision ahead of them.
Thank you all for coming out tonight, and I hope you all have a great rest of your week.
Thank you again. John.